To make an application for a non-molestation order, it has to be made on an application form called the FL401, together with a witness statement. A witness statement should set out a background history of the parties, together with the most recent incidents and the most significant incidents as well. It should follow a chronological order. For this reason, it is really helpful if the applicant keeps a diary. The application has to be sent to the court. Currently, there's no court fee to pay. Once the application is received by the court, they would list a hearing, which usually takes place within a week or two, depending on the court's timetable. At the first hearing, both parties would be required to attend. If the judge who's reviewing the application feels that the applicant would require some sort of protection from harm, then the order is likely to be made. Thereafter, if the respondent's challenging the order, the court would have to list a more substantial hearing, allowing the respondent to respond to the application and hear from both parties to give evidence and potentially to be cross-examined as well if they've got legal representatives. At the final hearing, if the judge decides to keep the order essentially in place, most of the time these orders are made for 1 year. An application for a non-molestation order could also be made on an emergency basis, which would mean if the applicant could be placed in harm if the respondent has notice of the application. In those scenarios, the applicant could send the application to the court and ask the judge to deal with this on an urgent basis. The judge would then normally review the application without a face-to-face hearing and potentially make the order if they think it's necessary. Because if the order is made on an urgent basis without notice to the respondent, then the respondent has to be given the opportunity to respond to the application, and therefore they usually list a review hearing within a week or two. The judge would then decide whether the order should still remain in place or should be withdrawn. An application has to be made carefully with evidence, and therefore preparation is key. An unsuccessful party could be ordered to pay the successful party's costs.